Hello, my name is E. Leonard Rubin, and I'm going to be talking today about the intersection of digital rights with copyright law and trademark law. I've been working in this area or these areas for most of an extensive career and finding it to not only be fascinating but also to be ever-changing. So today we're going to be talking about some of those changes, how interesting they might be, but how they also affect people, clients, attorneys, courts. And we will also be covering some of the confusing aspects of this area because there are plenty of those. This intersection doesn't have much in the way of traffic control, so portions of the rights may affect portions of the other rights. At any rate, we should have some interesting fun with it. I'm going to be looking down from time to time just to check on the PowerPoints that we will be covering. What are digital rights? What am I talking about? Well, there are rights that individuals have to perform actions that involve the use of computers. Digital, of course, you already guessed that that involves computers. But any other electronic device, smartphones, or a communications network. There are rights connected with the use of these kinds of implements, and they are an ISP provides the Copyright Office with a copyright designated agent. That's the person that gets the notification that something is awry, that some protected material is being used by somebody else without permission. And that is, it becomes a requirement under the DMCA for the ISP, the Internet Service Provider, to take the material down. It has to happen. There is no waiting for some other person to make an argument or for the uploader even to make an argument. It must be taken down. Now it can be put back up if the uploader insists that it's theirs. Without permission, even with the ability to change the material, to use it as some form of basis for something that is brand new. One of the other cases involving music is Sony versus Tenenbaum. And again, there were 30 songs that were found to have been unlawfully downloaded. Actually, in that particular case, there were a lot more than 30 songs. But because of the vagaries of litigation, that sort of thing, the parties winnowed it down to 30. And a finding, excuse me, a finding of guilty for downloading the songs, and an award of $22,500 per song. The total, in that case, is $675,000.